Can you apply for a T visa if you've been deported? My name is Ashley and I'm an immigration attorney. I'm going to talk about this in today's video. The short answer to that question is yes. It is possible to still apply for a T visa even if you've been deported in the past. Like most things in immigration law, there is a lot of nuance to this question, which I'm going to cover in this video. So generally speaking, when somebody applies for a T visa, there is a waiver that is available as well. And this waiver is extremely generous. It can waive things like a prior deportation order. It can waive certain criminal history. It can waive a lot of different kinds of immigration violations. So the point is that because this waiver exists, it is possible for somebody who otherwise qualifies for a T visa to still apply for it, even if they have a previous deportation. The nuance is that when you are applying for a T visa, you ideally want to make sure that you have not departed the United States since your trafficking victimization occurred. So that's to say, you want to make sure that you didn't receive the deportation order while you were being a trafficking victim. So that means, for example, if you were working at a job where you were being trafficked in a labor setting, and then for some reason you departed the United States with a deportation order, or even on your own, that could create complications for your T visa case. In very limited situations, it is still possible to apply for a T visa, even if you have departed the United States while the victimization is ongoing. But there are very specific requirements to meet in order to be able to still be eligible for the T visa in that circumstance. So the main thing to know is that if you have a deportation order that is very old, that happened before you became a trafficking victim, and you are currently in the United States and you have not departed the United States, then you can still be eligible to apply for the T visa, assuming you meet the requirements for the T visa, and even though you have the past deportation order. The last thing that I want to say on this topic is that depending on the kind of deportation order you have, you may be required to do additional things in your case in order to eventually get your T visa if it's going to be approved. So there's two ways that somebody can be deported. Somebody can be deported at a port of entry. That's when they are trying to enter the United States. They can get a deportation order at a border, or they can get deported from inside the United States by an immigration judge. So if you are somebody who has a prior deportation that happened at the border, then you will be able to apply for the T visa if you qualify, even if you have that old prior deportation order at the border, and USCIS will be able to adjudicate your entire case. If you are somebody who got a deportation order from an immigration judge, and then let's say that you never departed for some reason, there's a bit more involved in your T visa application process. You will need to eventually ask the court to remove that deportation order before your T visa can be approved by USCIS, because USCIS and the immigration court are two different agencies. So I hope you found this video helpful. Again, the short answer is that if you have a deportation order in your past, that does not necessarily mean that you are disqualified from filing for a T visa if you otherwise meet the T visa eligibility requirements. If you have further questions on this topic, don't hesitate to contact my office for a consultation. I have an office in California and in Oregon. My team and I handle most of our cases virtually, as our clients are located all over the United States. And you can contact us at 760-812-3778.